Good morning, this is your Kelso Report for Thursday, December 8th. I'm your host, Clark Kelso. Now, I've commented before on what appears to be a striking and persistent disagreement between the United States Supreme Court and most of the Ninth Circuit judges over how to apply the Anti-Terrorism and Effective Death Penalty Act's provisions dealing with federal court review in habeas corpus matters. Basically, the Ninth Circuit doesn't want to follow the Act's rules, which very strictly limit the role that a federal court can play in reviewing the merits of state court convictions and state court decisions in state habeas matters. Our featured case today, Gonzalez v. Wong, is nothing less than a nearly frontal assault by a majority panel of the Ninth Circuit on one of the Supreme Court's most recent habeas decisions, Cullen v. Pinholster, where the Supreme Court clearly held that in a habeas proceeding under the Act, a federal court may consider only the record that was before the state court when it adjudicated the claim on the merits. In Gonzalez v. Wong, the Ninth Circuit considered a habeas petition that raised a Brady claim regarding materials deliberately withheld by the prosecution that would have undermined the credibility of a jailhouse informant who testified at the trial that the defendant had confessed to the murder, of which the defendant was ultimately convicted. The Brady claim was raised in a state habeas proceeding, but was rejected, and that decision was reviewed and rejected by the California Supreme Court on the merits. And that was way back in 1990. Subsequent to those decisions, and during the federal habeas proceedings, new documents were obtained from the prosecution which, in the opinion of the Ninth Circuit majority, substantially strengthened the Brady claim, to the point that the argument would be potentially meritorious. That is, according to the court, a reasonable state court might be persuaded to grant relief on that claim. But under Pinholster, those new documents were clearly not part of the record before the state court, so the issue presented to the Ninth Circuit was whether the federal court could do anything with those documents. Well, we got three opinions from the Ninth Circuit panel. Judge O'Scanlan, who dissented, concluded that the new materials were simply irrelevant based on the holding in Pinholster that, quote, if a claim has been adjudicated on the merits by a state court, a federal habeas petitioner must overcome the limitation of the habeas statute on the record that was before that state court. That's Pinholster. Stated another way, evidence introduced in federal court has no bearing on habeas review, close quote. Now, a concurring opinion by Judge William Fletcher concluded that Pinholster simply did not apply in the extreme circumstances presented in this case, where, according to Judge Fletcher, the petitioner's failure to introduce the relevant evidence in state court is the fault of the state court. He reasoned to hold that an improper state court denial of discovery necessary to develop a federal constitutional claim prevents a federal court from considering in the first instance evidence discovered during federal habeas unnecessarily binds the federal court to the inadequate fact-finding of the state court. The underlying premise of this argument is, of course, that federal courts are supposed to be engaged in a broad search for the real truth when conducting habeas review. And that is not what the federal statutes now say, and certainly not the way the United States Supreme Court has interpreted them. As interpreted by the Supreme Court, federal habeas review is a narrow examination, essentially just of the internal reasoning of state court decisions, with a very high threshold for overturning those decisions. Finally, the lead opinion by Judge Clifton proposes what is rather clearly an attempted end run around Pinholster. Judge Clifton recognized that under Pinholster, the court cannot grant habeas relief based on the new evidence, since that evidence was not before the state court. But he holds that the court can use the new evidence as the basis for staying the federal court proceedings in order to give the petitioner an opportunity to return to state court and present his claim with the benefit of the new materials that were not available and not part of the record at the time of the California Supreme Court's decision 20 years ago. He reasons, quote, by that process, we seek to satisfy the intent of ADIPA, as discussed in Pinholster, that habeas claims of state prisoners be channeled in the first instance to state court, close quote. Well, Judge Clifton's result is certainly a reasonable one, if that's what the statute meant and that's the way the Supreme Court had interpreted it. But it seems to me it's inconsistent with the other main intention of the Anti-Terrorism and Effective Death Penalty Act, which was to bring finality to the habeas process and to rein in the federal courts, very narrowly limiting their role in considering collateral attacks on state criminal convictions. This case stands a good chance, I think, of going in bank, particularly with 3 separate opinions, and if it doesn't, I think we can be pretty sure the Supreme Court will grant a petition for cert, and a good chance the court will reverse. The battle between the Ninth Circuit and the Supreme Court over the role of federal courts in habeas proceedings continues on. Our second feature case today involves an arcane but tremendously important aspect of state constitutional law, the appropriations doctrine. The interpretation of the doctrine arose in the middle of one of California's most important issues, how to allocate water rights among California's diverse users, agricultural, urban, north, and south. The opinion yesterday was from the 3rd District in quantification settlement agreement cases, which was a consolidated appeal from the settlement of 3 separate lawsuits dealing with allocation of California's share of the Colorado River among the Imperial Irrigation District, the Coachella Valley Water District, and the Metropolitan Water District of Southern California. Those 3 major stakeholders struck a deal known as the Quantification Settlement Agreement and had some related agreements. One of the parties brought the deal to the trial court seeking a validation judgment affirming the legality of the deal. Other interested parties challenged the deal on various environmental grounds under CEQA. The trial court declared the Quantification Settlement Agreement to be unconstitutional under the appropriations doctrine, and given that holding, declared the CEQA challenges to be moot. So the only real issue before the 3rd District was whether the Quantification Settlement Agreement was valid. We have here an opinion by Judge Roby, one of the leading scholars and judges dealing with water law and environmental issues. And it took Judge Roby in the 3rd District only 166 pages to conclude that the agreement was indeed valid and that it did not violate either the appropriations doctrine or the constitutional debt limitation. The court's analysis of the appropriations doctrine issue was the most interesting part of the opinion. The agreement created an unconditional contractual obligation, that's what the agreement said, for the state to pay all mitigation costs beyond a particular amount for which the 3 other signatories were responsible. That sounded to the trial court a lot like the agreement committed the state to pay without an appropriation. And according to the appropriation doctrine, only the legislature may enact an appropriation to authorize money to be drawn from the Treasury. The 3rd District disagreed with the trial judge's conclusion. Judge Roby distinguished between a contractual obligation and the right to enforce that obligation through an action that leads to money being withdrawn from the Treasury. According to the 3rd District, there is nothing wrong with the state becoming contractually obligated, because no one can enforce that obligation through an action for breach of contract leading to damages judgment unless the legislature ultimately enacts an appropriation to pay for the judgment. As the court explained, quote, nothing in the agreement gives those 3 water agencies the right to enforce that obligation by drawing money from the Treasury without an appropriation by the legislature, close quote. Now, to you and me, that might sound a lot like the court is saying that the so-called unconditional obligation to pay is actually completely illusory, since its enforcement apparently depends upon the grace of a future legislature enacting an appropriation. But for the court, that was not a problem. In the first place, the mere fact that a contract may be voidable in the future does not render it illusory today. That's good contract law. In the second place, the court noted that even if the state ultimately did not directly appropriate funds to pay this obligation, a court still might be able to somehow reach other funds which had been appropriated for related purposes. That possibility was good enough. Now, this is all pretty technical stuff. I think it certainly leaves anyone who contracts with state government with a vague sense that the government's contractual obligations are not all that firm. At a minimum, it seems clear that if the legislature decides to breach and refuse to pay damages for the breach, there is not very much that California courts are inclined to do to help the non-breaching party. As a general matter, of course, the legislature does not involve itself in such minutiae, and the tens of thousands of contracts that are entered into each year are certainly not at risk from this opinion. But the opinion does suggest that high-profile contracts, the sort of contracts that might attract the attention of politicians in the legislature, those contracts carry higher risks of non-performance by the state, followed by non-payment of damages and non-enforceability. Now, the rest of the 3rd District's opinion was pretty tame stuff. It ultimately concluded that the quantification settlement agreement was valid, and the court remanded the case for consideration of the remaining environmental issues. This is an important case for the state, both because of the interpretation of the appropriations doctrine and because of the subject matter of the agreements, water rights. So it would not surprise me if the California Supreme Court decided to take the case just to put its imprimatur on the analysis and result. On the other hand, the court might decide to just leave well enough alone in order to avoid the possibility of blowing up what appears to be a reasonable settlement between the stakeholders. And now our one-liners, first to the area of franchise law. In Red Lion Hotels versus Mack, the Ninth Circuit held that Washington's Franchise Investment Protection Act, which contains a franchisee Bill of Rights, applied extraterritorially to a California-based franchisee, which brought suit against its Washington-based franchisor. The issue arose after the franchisor sent a notice of default and termination to the franchisee and filed a suit for breach of the franchise agreement seeking liquidated damages. The franchisee counterclaimed under the franchisee Bill of Rights. The district court granted summary judgment to the franchisor on the Bill of Rights claim, concluding that Washington's act did not apply to a California-based franchisee. The franchisor's claim for breach of the franchise agreement went to trial and resulted in a judgment in favor of the franchisor. The Ninth Circuit reversed, noting that, among other things, while some provisions in the Act expressly applied only within the state, the Franchisee Bill of Rights contained no language limiting its application to franchisees located outside the state. No language limiting its application to in-state franchisees. This difference in statutory language supported the Ninth Circuit's conclusion that the Franchisee Bill of Rights did apply to the California-based franchisee since there was no limiting language, and the court reversed and remanded for the district court to consider the franchisee's counterclaim. Next to the area of immigration, in Kwong versus Holder, the Ninth Circuit reiterated, for about the 3rd time in as many years, that a conviction for first-degree burglary constitutes a conviction for an aggravated felony which triggers an order of removal. It's an issue that's been before the Ninth Circuit several times, including most recently the court's decision only a few weeks ago in Lopez Cardona versus Holder, where the court flatly held that first-degree burglary was a crime of violence within the meaning of federal immigration law. With any luck, this issue will now go away as a matter of published opinions in the Ninth Circuit, having been definitively resolved multiple times. Our next case involves juvenile court. In re K.A., the 2nd District held that the 10-day time frame set by the rules of court for conducting a rehearing of a dispositional order are directory and not mandatory, and that absent any showing of prejudice, the violation of the 10-day rule is not a basis for reversing the court's final order. The 2nd District noted that the rule did not specify any particular sanction or consequence for missing the 10-day time frame, which meant to the court that the rule was directory only, and that a violation of the rule would not undermine the judgment unless there had been some showing of prejudice from the delayed hearing. In this case, the appellant fully participated in the hearing and could show no harm at all from the delay. Next, we have a case involving licensing. In Imports Performance versus Department of Consumer Affairs. The Second District held that a license for an advanced emissions specialist technician, essentially a smog check technician, is a non-professional license. And that means the burden of proof in an administrative license revocation proceeding would be by a preponderance of the evidence instead of by the higher clear and convincing evidence standard. The clear and convincing evidence standard is reserved for license revocations in the context of professional licenses, such as those held by doctors, lawyers, and real estate brokers. Preponderance of the evidence applies to revocation hearings for non-professional licenses, such as those held by food processors, vehicle salespersons, and now advanced emissions specialist technicians. The difference is that a professional licensee must undergo extensive educational training and testing requirements. Now, while there are some coursework requirements to become an advanced emissions specialist technician, as well as an examination, the requirements simply are not heavy enough to qualify as a professional license, according to the court. And that's it for today's Kelso Report. I'm going to be traveling on the road beginning late this evening, so there won't be a Kelso Report tomorrow morning. The next report will be next Monday. So have a great day in the law and a happy weekend.